Hello class. As promised, here is an overview of the key provisions of the Constitution for your test later this week. It would be helpful if you have your copy of the Constitution. As I go through, I'll try to point out some key things that you should highlight or put post-it notes on as you get ready to take your test. You will be able to use the Constitution on the test, but pay attention to the things that I focus your attention to during this presentation. The first thing that you should note is that Article 1 of the Constitution is not only the longest article and the most expansive in terms of the powers that it grants, but it's also important to note that it's first for a reason. The framers of the Constitution knew that they would be the ones implementing the powers that they were discussing. And especially for these haves who had just successfully won this war and now realized they had to make some of these promises that they had given to the have-nots real, they're going to clearly give themselves certain powers that in some ways look democratic but aren't necessarily so. So the first article of the Constitution deals with the legislative branch. One of the things that you should recognize is that there was an agreement made during the course of the Constitutional Convention. There was one group who really advocated that every state should get one vote in this new Constitution, so that every state was equal. There was another group that argued that it should not be that way, that it should be based on population, that the bigger states should have more say. So these two different plans, the Virginia plan, which was the big state plan based on representation, and the New Jersey plan, which was the small state plan where each state got one vote, was really one of the biggest arguments that happened during the Constitutional Convention. And it really ended up with what's known as the Great Compromise, or the Connecticut Compromise. And this compromise established two houses in the Congress. So within the legislative branch, you actually have two wings of the legislature. You have the House of Representatives and you have the Senate. And these two bodies become known as a bicameral legislature. Cameral means house, so two-house legislature. So the United States government has a bicameral system that compromises those two plans. The House is based on population, so larger states have more members in the House of Representatives. The Senate is based on each state getting two votes, so every state has two senators. And this House versus Senate is going to be really important as you look at the way the powers break down under the Constitution. Notice on page 154 of your Constitution that they list the House of Representatives first. Ask yourself why they would do this. They would do this so that the common people who are going to elect these House members every 2 years would feel most closely connected to those individuals. And more importantly, they're going to see them as being the most important. But as you'll see here in a second, the House of Representatives has far less power than the Senate has. So each member of the House is based on population, and each state gets a certain number of House members based on the population of their state. So for example, today, California has the most House members with 53, and the least is 1. North Dakota, for example, only has 1 member of the House of Representatives because their population is so small, they only get 1 House member. So as you go through, each state has a representation that's equal in the Senate, but certainly not equal in the House of Representatives. The House was given two powers that the Senate does not have. They were given the power to impeach the president, but all that means is you're charging the president with a crime. Impeachment does not mean removal. It just means charging with a crime. So the House has the power to charge the president with a crime, and the House must be the place where any tax laws start. Both of those things were given to the common people to make it seem like they had a lot of power in the system. But as we'll see as we now flip to the Senate, that was certainly not the case. In the Senate, they have specific powers that are unique to them. For example, the Senate has the power to approve all presidential appointments. The Senate has the power to approve all presidential treaties. So they become the check over the power of the president. In addition to that, anything that passes through the House, even a tax bill, has to go through the Senate also. So the senators who were in the original Constitution to be appointed by the state legislatures, clearly those people were intended to be the haves that were writing this document. It's interesting to note that the people writing the Constitution gave themselves the largest source of power in the Constitution itself. They have a huge check over the power of the president, and they also have a check over the House members who might pass tax laws on to them. In addition to that, who do you think gets to decide the impeachment trials of the president? None other than the Senate. So the Senate can also remove the president from office at the end of an impeachment trial. It's never happened in American history, but it's come close a couple of times. So when you think about the House and Senate, it's important to look on page 157 of your Constitution, which outlines the provisions of how a bill becomes a law. It's really important that you note how a bill becomes a law, because this process, which we look at seeming to start in the House with tax law, is actually not necessarily the case. And there is a check on the power of the common people. So any common law that might pass through for the common people's good still is checked by the elites in the Senate and the elite president who can veto it if he doesn't like it. So the real power in Article 1 comes from the Senate, and it's important to remember that. Now, if you look at the powers that are listed on page 158, Article 1, Section 8, you definitely want to put a post-it note on that page, because those are the powers specifically granted to Congress. If you look down at Clause 18, which is known as the Elastic Clause or the Necessary and Proper Clause, it becomes sort of a catch-all category, which basically says there's a bunch of stuff we haven't been able to think about here, and as a result, we're giving the Congress the power to do anything that relates to any of the 17 things listed above. So Article 1, Section 8, Clause 18 is one of the most important aspects of the entire Constitution. As we move on to Article 2, one of the things we see really quickly is that the executive branch has one real clear power, and that power is to execute the laws. The idea for the president was that the president was going to be in some ways a figurehead, a very famous person probably, who could be the face of the US government, but more importantly would be charged with making sure that all the laws that Congress passes get carried out. So the president was to be selected by the Electoral College, which basically made sure that it would be somebody elite, because the states got to choose their electors, and they would vote for the president and vice president that they chose. And the person who got the majority of electoral votes would become the president. The person who got the second most votes would become the vice president. That was under the original Constitution, before Amendment 12 allowed the president and the vice president to run on one ticket. But when you think about the powers of the presidency, they're very limited. And that tells us a lot about what the framers intended. The president was not supposed to be this powerhouse that we see today. The president was to be a figurehead ceremonial position. The president has executive power, which means they execute the laws, and anybody that works under the president has to follow the president's policies in how those laws are carried out. But in terms of other powers for the president, if you turn to page 161, you'll see that they're very limited. The president is the commander-in-chief. The president gets to make treaties and sign treaties with other countries. And the president gets to appoint various officers of the government, including Supreme Court justices. But all of those treaties and appointments come at the discretion of the Senate. Only if the Senate approves do those things happen. So there's a huge check on the power of the president. The only other power the president has, if you look at the president's powers, this idea of war, treaties, and appointments, you have those powers, but you also have the ability once a year to give a State of the Union speech. It used to be these speeches were just delivered in a letter to the Congress. Today, the tradition is that the president, sometime in January, comes to address a joint session of both houses of Congress in giving his State of the Union speech. So the president really just sets the agenda. And under the original Constitution, the powers of the president were very, very limited. What we've seen happen over time, though, is that the presidents of the United States, all 44 of them over the course of American history, have bent the job to their will. They have actually made themselves far more important than were ever intended by the framers. So it's important to note that. Moving on to Article 3, the judicial branch is even shorter than the executive branch. So we have some clear evidence here. Article 1 is the longest, it has the most listed powers. Article 2 is shorter with very few listed powers. And Article 3 is the shortest with the least amount of powers listed. All it basically says is that there will be a court system and the Congress can set up that court system, including creating a certain number of justices of a Supreme Court who will hear big cases. Now, under the original Constitution, you'll notice the only cases that the Supreme Court hears under their original jurisdiction are cases related to treason or cases that have one state suing another state. So the judicial power was very limited in the original Constitution, and it was sort of a to be determined category, which we'll see what happens as we move forward. So this idea of a to be determined court leaves a pretty wide open category for Article 3. The judicial powers were very vague in the original Constitution. Article 4 deals with how states respect each other. It was very clear during the debate in the Constitutional Convention that one of the issues was how much sovereignty individual states were going to give up. Under the Articles of Confederation, remember, the states were supreme. They could ignore other states if they wanted to. But under this new Constitution, they had to respect each other's laws. So every state in the Union today has to respect the laws of other states. And that's going to be a very important issue related to lots of these state laws that might contradict other laws in other states. Article 5 deals with how the Constitution is amended. And there are two ways that the Constitution can be amended. So it's really interesting to note that even though there are two different methods for changing the Constitution, it's actually only happened 27 times since 1789. That's a tiny number of times to change the document for the government that runs our system every day. Here are the two ways to amend the Constitution. The first way is that 2/3 of the Senate and the House, so the members of the House and the Senate, 2/3 of both branches there, 2/3 of both houses of Congress, propose and pass an amendment. That amendment then would go to the states to be ratified. The other possible way is that 2/3 of the states would propose and pass an amendment, and then it would go to the states. So there's two ways for an amendment to be proposed. 2/3 of both houses of Congress agree, or 2/3 of the states agree. If either of those things happen, it goes back to the states, and 3/4 of the states have to approve it. So it's very, very difficult for an amendment to be passed to the U.S. Constitution. And it's important when you think about this that you realize that the first 10, the Bill of Rights, were ratified on day 1. So in reality, there's only been 17 amendments in the history of the Constitution. We'll talk about why that is later on. Article 6 declares that the federal government is supreme, that the national government has priority over the state governments. And any time a law at the national level contradicts a law at the state level, the national law wins. That means that if the state of New Jersey passes a law that says one thing, but the U.S. government, the Congress, passes a law that says something else, and everybody votes on that law in Congress and the president signs it, that law takes priority over any state law. This is known as the Supremacy Clause. This has wide-ranging consequences, even today, for lots of current issues. The gay marriage issue is certainly an issue where there's a federal law called the Defense of Marriage Act that says marriage is between a man and a woman, and now there are several states in the Union that have legalized gay marriage. So that's a clear contradiction. The question is, will the federal government enforce the law over those states? The other issue is the issue of legalized marijuana in places like Colorado, where recreational use of marijuana has now been legalized despite the fact that it's illegal by national law. So I guarantee these two issues are going to come to the forefront in this debate, and the Supreme Court's going to have to decide where these things come down. Should the state law win or should the national law win? And we'll see how that all plays out in the weeks and months ahead. The last thing you should really note about the Constitution are the amendments. And we're going to talk a lot about the amendments later on in this class as they're added to the Constitution, particularly the 14th Amendment, which is going to be one of the most important in the entire Constitution. But for now, you should really focus on knowing and understanding the first 10 amendments to the Constitution. I sent this handout for you. This first 10 amendments are known as the Bill of Rights. Now, the Bill of Rights are added on day one because there were a group of people who were involved in drafting the Constitution who felt that they had gone too far in creating too much power for the national government. And they worried that states and individual citizens were going to suffer because of the powers of this all-powerful government. So what they did is they made a list of rights that could not be taken away. Many of the states already had bills of rights, but now they're going to have a list of 10 things that really protect individuals and states from the power of the national government. This is the only way they could get the anti-federalists to go along with the Constitution. So once the document was drafted, there were a whole group of people supporting the Constitution, led by Alexander Hamilton and James Madison. They were known as the Federalists. And then there was another group who were opposed to the Constitution. Thomas Jefferson was actually part of that group, who were arguing against it, saying that the power of the national government was too strong. And these anti-federalists tried to argue that they needed more protection. And because of their argument, a Bill of Rights was promised and passed the early days of the new Constitution, of the new Congress, and the states approved them right away, making sure that certain rights could not be taken away. So let's look at these 10 amendments to the Constitution. I've actually sent you this chart as a PDF, and you might want to take a look at it as I go over these quickly. So let's look at the first amendments to the Constitution. The First Amendment guarantees the freedom of religion, speech, the right to argue against the government or petition the government for grievances, the right to peaceably assemble, and the right of the press. Those things cannot be taken away under the First Amendment. The Second Amendment gives the right to bear arms. And the Third Amendment says that no time can soldiers be put in any house without the consent of the owners. You can see all three of those things directly relate to the rights of the have-nots during the War for Independence. The Fourth Amendment to the Constitution, on the right-hand side here, the Fourth Amendment to the Constitution is the Illegal Search and Seizure Amendment. It's one of the most used amendments in the Constitution. It requires that the search be both reasonable and with a warrant certified by some outside source, so that you can't pick on people and try to punish them without a court saying that you have legitimate reason to suspect them. The Fifth Amendment basically guarantees that you get to have a trial. It guarantees that you get due process, that you're charged with a crime, that you can't have a trial twice for the same offense. And most importantly, the Fifth Amendment says you do not have to incriminate yourself. So you're not forced to admit wrongdoing. If you choose to plead the Fifth, you can argue that you're not going to say anything because saying something might prejudice people against you. So that happens quite a bit in trials. The Sixth Amendment guarantees a speedy and public trial, and also says that that trial must be by jury if you request it. The Seventh Amendment guarantees that civil trials are held by jury, that if any case, a civil trial is not, the difference between a civil and a criminal case, a criminal case would be where you've committed some sort of crime. A civil case would usually involve some sort of monetary damages. So you might have, you might owe somebody money in some way. That would be a civil case. Maybe you've damaged their property. That would be a civil case. So anytime a civil case exceeds $20, you get the right to a trial by jury if you choose. Moving on to the 8th, 9th, and 10th Amendments. The 8th Amendment says there's no cruel and unusual punishment. Now, interestingly enough, you would think that capital punishment, the death penalty, might be cruel and unusual, but the courts have actually said that it's not, as long as it's a humane method of death. I'm not really sure how that works, but that's what they've argued. Now, the 9th and 10th are, again, similar to Article 1, Section 8, Clause 18. They're sort of catch-all categories. The 9th Amendment says that the list of rights in the Constitution is not meant to be perfect, that it's not meant to suggest that there aren't still other rights out there that belong to the people. And the 10th Amendment says anything not listed in the Constitution, nor told to the states that it's prohibited, is reserved to the states or the people. So if the U.S. government doesn't do something, doesn't have the power to do it in the Constitution, states can if they want. And if the states choose not to, people have the right. So this gets back to the question we had about the Bank of the United States. Is it okay or is it not okay under the Constitution? So these are the amendments to the Constitution, the Bill of Rights as they're known. The Constitutional Convention went on for 2 years, from 1787 to 1789. And in that time, it was blistering hot in Philadelphia in the summertime. They finally came to agreement, sent the Constitution out to the states, and it was finally ratified, with New York being the state to put it over the top in 1789. So the Constitution becomes enacted at that point, and there's a lot of things you should think about related to the Constitution. But the most important is that in order to get it passed, in order to get it compromised, they really had to leave it vague in lots of areas. The only place where there's really a lot of clarity is in the powers of the House and Senate. The presidency is pretty unclear. The judiciary is pretty unclear. We know that the U.S. government is supreme, but beyond that, we really don't know how it's all going to play out. And so you've got to think about this Constitution as being like a roadmap for people to follow. But that roadmap is pretty blurry, and it's going to be pretty hard to read and implement when it's so unclear. So the vagueness of the Constitution is going to be both its greatest gift and its greatest enemy. And we'll talk about that as we move forward. I hope this was helpful. Please email me if you have any questions, and I'll see you in class.